Will Elena Kagan Allow Books to be Banned? By Daniel Schuchman. Understanding the Supreme Court nominee's chilling argument in Citizens United. As Solicitor General of the United States, Elena Kagan argued in front of the Supreme Court that the federal government had the constitutional authority to ban certain political pamphlets. She also strongly implied that some political books, if they were partisan enough, could also be censored. Kagan's extraordinary claims emerged during the second oral argument of Citizens United versus Federal Election Commission, the campaign finance case made famous by President Barack Obama when he publicly excoriated the justices for their ruling during his State of the Union address. The president alleged that Citizens United would allow corporations to subvert the political process with their economic power. In fact, the case concerns the fundamental political liberties of all citizens. The true stakes were dramatically revealed in the 2 rounds of oral argument heard by the court. In the first argument before the court, on March 24, 2009, Kagan's deputy, Malcolm L. Stewart, represented the government by arguing for the constitutionality of a statute prohibiting corporations and unions from spending funds from their general treasuries to advocate the election or defeat of political candidates. The justices subjected Stewart to a series of stark hypothetical situations, testing the extent of the censorship power that the Obama administration viewed as constitutionally permissible.
If it has one name, one use of the candidate's name, it would be covered, correct?
That's correct.
If it's a 500-page book and at the end it says, and so vote for X, the government could ban that.
Well, if it says vote for X, it would be express advocacy, and it would be covered by the pre-existing Federal Election Campaign Act provision.
No, I'm talking about under the Constitution, what we've been discussing, if it's a book.
If it's a book and it is produced, again, to leave to one side the question of
forget the
possible media exemption. If you had Citizens United or General Motors using general treasury funds to publish a book that said at the outset, for instance, Hillary Clinton's election would be a disaster for
this. Take my hypothetical. It doesn't say at the outset. It runs, here is a, whatever it is, this is a discussion of the American political system. And at the end it says, vote for X.
Yes, our position would be that the corporation could be required to use PAC funds rather than general treasury
funds. And if
they
didn't, you could ban it.
If they didn't, we could prohibit the publication of the book.
Even the most liberal justices, usually the most willing to curtail political free speech, seemed a little troubled. Justice David Souter asked what would happen if...
Why?
I want to know how far your argument would go. What if a labor union paid an author to write a book advocating the election of A or the defeat of B, and after the manuscript was prepared, they then went to a commercial publisher, and they got a Random House. Random House says, yeah, we will publish that. Can the distribution of that be, in effect, subject to the electioneering ban because of the initial labor union investment?
Well, exactly what the remedy would be, whether there would be a basis for suppressing the distribution of the book, I'm not sure. I think it's clear under...
Oh, does it come within electioneering because of the initial subvention to the author?
It wouldn't be an electioneering communication under BICRA because BICRA wouldn't apply to the print media. Now, it would potentially be covered by the...
No, but we're talking about how far the constitutional ban could go, and we're talking about books.
Well, we would certainly take the position that if the labor union used its treasury funds to pay an author to produce a book that would constitute express advocacy,
and the book was then taken over as a commercial venture by Random House.
The labor union's conduct would be prohibited.
Later, the argument turned to other forms of media that the government would have the right to censor. The implications of the administration's position were so enormous that Justice Antonin Scalia seemed almost incredulous. He sarcastically interrupted to say, quote,
disoriented here, Mr. Stewart. We are dealing with a constitutional provision, are we not? The one that I remember, which says Congress shall make no law abridging the freedom of the press. That's what we're interpreting here?
That's correct.
Okay.
But again, the court obviously has grappled.
The justices were apparently concerned by what they heard, requesting an unusual second oral argument in the case on September 9, 2009. This time, Kagan went to the Supreme Court herself. Justice Ruth Bader Ginsburg got right to the point by asking Kagan
one question that was highlighted in the prior argument, and that was if Congress could say no TV and radio ads, could it also say no newspaper ads, no campaign biographies? Last time the answer was yes, Congress could, but it didn't. Is that still the government's answer?
The government's answer has changed, Justice Ginsburg.
Which sparked laughter in the courtroom. Given the skeptical questioning at the prior hearing, Kagan seems to have made the tactical decision to back off from her office's initial claims and opted to craft a less controversial way of getting the justices to accept significant restrictions on free speech. She assured the court,
and we took the court's own reaction to some of those hypotheticals very seriously. We went back, we considered the matter carefully.
Perhaps this is an example of her reputed pragmatism and interest in building coalitions. In any event, her attempted finesse did not stand up so well under cross-examination. Kagan conceded
that the FEC has never applied 441B in that context. So for 60 years, a book has never been at issue.
What happened to the overbreadth doctrine? I mean, I thought our doctrine in the First Amendment is if you write it too broadly, we're not going to pare it back to the point where it's constitutional. If it's overbroad, it's invalid. What happened to that?
I don't think that it would be substantially overbroad, Justice Scalia, if I tell you that the FEC has never applied this statute to a book. To say that it doesn't apply to books is to take off, essentially nothing from historic.
We don't put our First Amendment rights in the hands of FEC bureaucrats. And if you say you're not going to apply it to a book, what about a pamphlet?
I think a pamphlet would be different. A pamphlet is pretty classic electioneering. So this is no attempt to say that 441B only applies to video and not to print.
Well, what if the particular movie involved here had not been distributed by video on demand? Suppose that people could view it for free on Netflix over the internet. Suppose that free DVDs were passed out. Suppose people could attend the movie for free in a movie theater. Suppose the exact text of this was distributed in a printed form. Now, in light of your retraction, I have no idea where the government would draw the line with respect to the medium that could be prohibited.
Yes, well, none of those things, again, are covered.
No, but could they? Which of them could and which could not? I understand you to say books could not.
Yes, I think what we're saying is that there has never been an enforcement action for books. Nobody has ever suggested, nobody in Congress, nobody in the administrative apparatus has ever suggested that books pose any kind of corruption problem. So I think that there would be a good as-applied challenge with respect to that.
So you're a lawyer advising somebody who's about to come up with a book, and you say, don't worry. The FEC has never tried to send somebody to prison for this. The statute covers it, but don't worry, the FEC has never done it. That going to comfort your client? I don't think so.
But this statute doesn't cover books.
No, that's exactly right. The only statute that's involved in this case does not cover books. So 441B, which
does cover books.
Which does cover books, except that I've just said that there would be a good as-applied challenge and that there has been no administrative practice of ever applying it to books. And also only applies to express advocacy, right? 203 has a broader category of the functional equivalent of express advocacy, but 441B is only express advocacy, which part of the reason why it's never applied to a book is one cannot imagine very many books that would meet the definition of express advocacy as this court has understood that.
Oh, I'm sorry, that we suggested some in the last argument. You have a history of union organizing and union involvement in politics, and the last sentence says, in light of all this, vote for Jones.
I think that wouldn't be covered, Mr. Chief Justice. The FEC is very careful and says this in all its regulations to view matters as a whole. and as a whole, that book would not count as express advocacy.
She strongly implied that if the book engaged in, quote, express advocacy, end quote, as a whole, it could be banned. Her position would seem to require the FEC to define the differences between books and pamphlets and decide how many sentences in a book are necessary to qualify as express advocacy. Kagan never addressed whether it was desirable for FEC staffers to become either book reviewers or a de facto national censorship committee. Ultimately, the court ruled against Kagan by a 5-4 margin. Many questions remain unanswered about Kagan's comfort with banning political publications and limiting free expression in other media. She might say that her own views on these issues are private and that she was merely advocating for her client in this case. However, it is interesting to note that in nominating Kagan, President Obama went out of his way to praise her defense of ordinary citizens against, quote, unscrupulous corporations, end quote, citing her work on Citizens United in particular. Quote, despite long odds of success, with most legal analysts believing the government was unlikely to prevail in this case, Elena still chose it as her very first case to argue before the court, end quote, Obama declared. Yet Obama and Kagan both ignored the fact that not all corporations that advocate for candidates are big and unscrupulous. Most are sole proprietorships of small businesses, and many are nonprofits, as was the plaintiff in Citizens United. As the Senate considers her nomination this week, they ought to ask her the following. 1. If a citizen who is the sole owner of a corporation that operates a bakery wants to use his business funds to put a candidate's poster in his storefront window, can that be banned under the Constitution? 2. If a group of like-minded citizens form a corporation for the purpose of advocating for candidates in whom they believe, can that corporation constitutionally be prevented from spending money? 3. Is it constitutional for the FEC to review political books for content and ban them if they run afoul of a campaign finance law? 4. Is it constitutional for media companies to publish content advocating for political candidates? If so, why should they be different from other companies under the Constitution? 5. If a corporation or labor union produces a pamphlet with its own funds advocating the election of a candidate, can that document be banned under the Constitution? The answers would reveal a lot about what kind of justice Kagan might be and how she reconciles her views with the First Amendment. Perhaps more importantly, it would be an opportunity for the public to see what is truly at stake when the government wants to restrict an individual or corporation's ability to support the candidates of its choice.